Our next presenter is Robin Matthews. Robin Matthews has been an associate legal counsel with the Ohio Department of Public Safety since March 2008. As the department's public records manager, she has overall responsibility for managing the department's public records requests. Ms. Matthews also serves as legal counsel for Ohio Homeland Security. So please welcome Robin Matthews.
Good afternoon. Well, I guess you guys just answered my question. Usually I do this right before lunch, and I'm thinking, okay, they've got me after lunch. I wonder how that's going to go. I will still do my best to stay on schedule, to get you out on time. I know when we do this before lunch, everybody's hungry and they're ready to go. So just to give you a little bit more information about myself, how many of you have seen that commercial about Snickers and you're not yourself when you're hungry? That is me, and I have not had lunch. So I have an agenda, too, in staying on task today. Before I get started, I want to also let you know that today is your lucky day, because not only are we going to talk about the wonderful and exciting subject of public records, you're also going to get two for the price of one today. I have with me Jacqueline Bauman, who's our legal intern. She's a third-year law student at Capital University, and she is going to be presenting part of the materials today. Before we get started, I would just ask that unless you have a really, really burning question, and I know there will be a few because, after all, this is public records, but if you can just hold your questions till the end, we'd appreciate it. I am going to go over some of the basics, pretty much the review about public records, receiving request, what a request is, et cetera, and then Jacqueline's going to follow up talking a little bit about how to respond to request and give you an update on some important case law that may impact how you, in fact, respond to requests. So first of all, let's talk about what a record is. How many of you know that? Yay. Well, for those of you that don't, a record is any device, item, or object, and there's a two-pronged test. It is either created, generated by, received by, or comes under the jurisdiction of a public agency. But just as important, it must also document the functions of the agency. So, for example, if somebody sends you a catalog or unsolicited mail, yes, it's received at your agency, but it doesn't document the function of your agency unless, of course, you use it. The important thing to keep in mind about that, a few years ago, the big issue I had when making these presentations was getting people to understand that, again, it doesn't matter the format. So emails, for example, are records. The same holds true now that we're in the age of social media. And I think you had a presentation about that today, or you will later. But keep in mind, if your agency has a Facebook page, public records. If you have a Twitter account, public records. So you have to follow the same rules and regulations that apply to those mediums as well. A public record is any record that is kept by a public agency. Kept by means you actually have to be in possession of that. That's very important because if you give a record to another agency, for example, you provide it to a prosecutor if you're a law enforcement agency, and you're no longer in possession of that record, it is not your agency's record anymore. The other thing to keep in mind in terms of kept by is that if you've destroyed the record, then it does not apply. It is not a record, and you don't have to deal with that when responding to public records requests. The record must actually be in existence at the agency at the time that the request is made. Public Records Act versus FOIA. Before I go into that, I also want to point out that multiple agencies can be in possession of the same record. So, for example, if a memo is sent to multiple agencies, or even if one agency is CC'd on that record, it becomes your original record, not just a copy, if in fact it documents the function of your agency. So let's talk about Public Records Act versus FOIA. Do you all know what FOIA is? FOIA is the Freedom of Information Act. There are big differences between public records and FOIA. We often get public records requests that start off, pursuant to FOIA, I would like blah, 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 blah. Well, guess what? FOIA does not apply to state agencies or local agencies. FOIA is a federal act that only applies to federal agencies. So if you are a state agency, FOIA doesn't apply to you. If you are a branch of the Social Security Administration located within a state, FOIA is going to apply. It's important to remember those differences because there are different requirements. For example, FOIA often has time constraints in terms of when you must reply to a request. The Public Records Act doesn't. If you receive a request under FOIA, the important thing to do is to, one, I try to educate requesters, let them know that FOIA doesn't apply, but that does not let you off the hook. You still need to respond to the request as if you had received it under the Public Records Act. When I talk some about requests, I'll go into that a little bit more. Requesting public records. The interesting thing, again, there are different requirements for FOIA, but under Ohio's Public Records Act, anybody can make a public records request. You do not have to be a citizen of the state of Ohio to make the request. You can make it in whatever manner you choose to. You can pick up the phone and call. You can submit a written request. You can email it. You can make that request in person. It does not matter. Two things that I think we need to stress here. One is the person does not have to say, I am making a public records request for it to be a valid request. They do not have to say anything at all, really. They can just say, I want Robin Matthews' personnel file. That is a valid public records request. The other key thing that's a little bit different in our state, I think, you can make a public records request anonymously in Ohio. So you do not have to give your name or any identifying information. It may make it a little tricky when you're trying to respond to a request, and you have to work through that, but a requester is not required to give you any of his contact information, and they're also not required to let you know the purpose of the request. Those are two things that a lot of people who are dealing with public records requests may not be aware of. The reason I want to make sure that you understand that, because under Ohio law, we cannot ask a requester for that information. If a requester says, hey, I want to make a public records request, we can't say, okay, you got to put it in writing. Ohio law doesn't require that. We can't say, okay, you got to give me your name, your mailing address, etc. Ohio law says we can't do that. There is a catch. We can do that if and only if we let them know that they are not required to give us that information. And then also if providing that information is going to assist us in fulfilling their request. Usually that comes into effect if it's a large request, if they're not sure what they want. And so then once you make that disclosure and let them know that they do not have to provide that information, if you explain that, look, it's not really clear, perhaps if you tell me the reason for the records, I can help you narrow it down and get you what you need. A request, in order to be a valid request, must actually be a request for records. Again, we don't have an Information Act, so technically under Ohio, unless it comes under some other state statute, we don't have to provide any information. We have to provide records. So if somebody, for example, says, hey, I want to know how many people work at the Department of Public Safety, that's a request for information. If they say, I want a list of all of the people that work at the Department of Public Safety, then that's a request for records. And then lastly, the request must specifically identify the record or the records being sought. Oftentimes they're overly ambiguous or they're overly broad. A usual way that you can tell that is if it starts off with the phrase, I want any and all. So if you get that, that's usually going to be a tip that it's overly broad. You'll also see that a lot in requests that aren't technically public records requests, but they may cite 14943 or they may not, but sometimes discovery requests, and those typically will have any and all, or subpoenas. Again, those aren't public records requests, but just keep that in mind as you receive those types of requests. Next, I want to talk about record retention. A lot of people don't really get the connection between public records and record retention, but under Ohio law, for every record that's created and kept by a state or public agency, you have to have an approved record retention schedule. What that means is that you cannot throw away anything. You can't shred, delete if you do not have an appropriate record retention schedule. There's an annual process, and I won't go into that, but please keep that in mind. If you do have a valid record retention schedule, that's a wonderful thing for a number of reasons. One, you don't have to keep storing all of those records, whether it's hard copy or electronically. And probably the most important reason to me is you can get rid of records and then you don't have to give them out when you get a public records request. Now, that's not to say that we don't want to give people the records that are public and that we need to give out, but here's the issue with the records retention schedule. If you have a record retention schedule that allows you to destroy that record and you do not destroy that record, if somebody asks for it, you have to give it out. You can't go, oh man, I meant to throw that out last week. You have to give that out. Where we run into issues sometimes have to do with union employees. There are certain records that, the contract negotiates, we're not going to have these. Again, if we have them, we have to give them out. In our office, for example, administrative investigations are retained for 5 years. I have had the unpleasant experience of explaining to somebody who's upset because an investigation report was released and it happened 10 years ago. The bottom line was we had the record under public records law. We're required to give that record out. So those are just a couple of things to keep in mind. I am now going to turn it over to Jacqueline, who is going to talk a little bit about responding to public records requests.
Good afternoon. My portion begins with how to respond to requests. And one way to begin responding to requests is to acknowledge the request. This is not required, but there are benefits to sending a letter to the requester acknowledging that you have received their request. Requesters like to call or email wondering, where's my responsive records? Why haven't you given them out? Why haven't I heard anything? By sending an acknowledgement letter, you are letting them know that not only has it been received, but that it is being processed. You may still get these calls anyway, but it makes you seem like you are being helpful, that it is going along the process. So you may want to consider sending the requesters an acknowledgement request, an acknowledgement letter when you get the request. Robin has already touched on overly broad requests, but if you receive such a request, you have a duty to inform the requester that what they are requesting is overly broad. And then the requester has a duty to revise or narrow it. But they do not have to narrow it until you tell them to. And along with that, you have to inform them of the manner in which you keep your records so that they can revise or narrow the request that way. If you have a request where only some of it is overly broad, but you can still identify other requests that have identifiable records that you can send, you have to send those identifiable records and notify them that the other requests are overly broad and they need to narrow it. Our office also provides retention schedules along with notifying them that the request is overly broad so they can narrow their request per our retention schedules. While agencies are not obligated to revise the request for the requesters, you may want to consider giving them advice on how to narrow their requests, such as providing a subject matter, limiting the time frame, giving the format of the record, or identifying the persons involved with the record, because oftentimes they will not do that. A statutory obligation for providing responsive records is providing them in a reasonable amount of time. This is an undefined amount of time, but it should include the time it takes to locate the record, to review the record, and if necessary, to redact the record. What this reasonable amount of time means is you have to exercise due diligence. You cannot just take your sweet time. If you think it's going to be complicated, you'll get to it later. You should always be reasonably working on it. I suggest that you do not give requesters a specific period of time for when they should expect their records, because they will hold that against you. Many times we want to seem helpful and tell requesters, oh, I can get that to you next week, or I should be able to get that to you in 2 weeks. But things come up, the request may be more complicated than you anticipated, and if you do not provide those records in that time period, they will be very angry and could throw that in your face, basically. So what I do is I'm always cautious and tell them I will get that to you as soon as I can. Another statutory obligation is providing the records at cost to the requesters. At cost means the actual cost of copying the records and delivering it to the requesters. This does not include the staff hours we may put into these requests. Even if we spend 40 hours working on this request, we cannot bill them for all that time slaved on their request. Since the at cost is only for the cost of copy and delivery, if they want to come in and inspect the records, or if they want it emailed or faxed, that obviously does not cost any money to them. We cannot put arbitrary amounts on requests. Some states have different obligations and can charge their requesters a standard fee to make a request, or if they've made a certain amount of requests and it's getting ridiculous, they may charge them for any subsequent requests, but we cannot do that. We have a statutory obligation to just provide records at cost. We provide records in their existing format, or a format that can be reasonably duplicated. This means that we provide the records the way we maintain it, unless they request for it differently. For example, if we have hard copies of records and they want an email, that is reasonably duplicated, and we can provide that to them in an email form. This isn't as big of a concern anymore, but for example, if someone requested records to be put on whatever an 8-track is, that is not reasonably duplicated. Sorry, I'm young. But an 8-track is not something we can reasonably duplicate records onto. But a good example of what is one way we can deny a request is if an agency has a unique machine or software that they view or create videos on, for example. If the requester does not have this software and is not reasonable for them to download it, that's not really our problem. We maintain our records the way we need it. And if this software is important for us and they cannot have this software, then they are out of luck, because that is not reasonably duplicated. I thought you would all like the 8-track thing. Redactions. Some information on public records may need to be redacted or taken out. Only non-public information must be redacted, and if you do make redactions, you must provide legal authority for why those redactions are being made. And if you are going to redact, I encourage you not to do it by hand. Highlighter and magic marker do not work very well. Preserve records. Sometimes you may receive record requests where the requesters tag on at the end asking us to preserve or hold these records. What they are wanting is for us to hold these records and not destroy them pursuant to our retention schedules. There is no statutory obligation to hold records past their retention schedules. However, my office, for example, if we anticipate a lawsuit involving these records, we may use our discretion and hold those records past their retention schedule, but there is no statutory obligation to go with their request and hold it for them. Rolling responses. You may receive really large requests or multiple requests from the same requester, and you can anticipate that this is going to be time consuming. So one thing you may want to consider is doing a rolling response. When you receive such large requests or multiple requests, I suggest that you negotiate with the requester on how you want to proceed with giving them their responsive records. They might be fine with you gathering the responsive records and providing them all at once, even if that might take a long period of time. Or you could negotiate with them with doing a rolling response, which would be you providing the records to them as they become available to you. That way they're not waiting days, weeks, months to receive their records. They can receive them throughout that time period so that at least they have something. Communicating with requesters. Communication is crucial, both external and internal. And if you think that you want to contact a requester, for example, if there are problems with the request or if the request is overly broad and you want it to be narrowed, you may want to consider calling that requester. If you do end up calling that requester, I suggest you write a letter documenting what you discussed and sending that to the requester so that they have a document of what was discussed and they can't try and throw it in your face later that you talked about this, this, and this if that's not what you talked about. You can have that record and show them this is what we discussed, this is how I was trying to help you. There you go. If you contact them via email, obviously that is a record in itself. But contacting requesters in general just shows that you are being helpful, you are trying to process their request, and that might make them a little more at ease and reasonable to work with. Sometimes we get difficult requesters. These are the people that feel they are entitled to unredacted records. They demand their records yesterday and they want it yesterday. These are the people that send multiple requests to multiple departments for the same thing, trying to get someone to respond. They yell on the phone. They think the exemptions don't apply to them. They may be used to easier routes and they don't know why the public records law is so complicated and why it's so difficult to get their records the way they want it. If you encounter these difficult requesters, I just suggest, be calm and communicate with them what the law is, why their request is different from what the law entitles them to, what your office policy is, and if they need help revision, that you are willing to help them revise if that's an issue. That leads me into how do we avoid problems? These difficult requesters may cause problems for your office. They may not agree with what you are telling them, with what you have provided, with how you have provided it, and they may complain about you or they may pursue a lawsuit, for example. And the way I would treat all requests, whether they are difficult requesters or not, just any request you get, I would view the request and your responsive letter and responsive documents the way a court would view it. Was the request actually ambiguous or overly broad? Were the exemptions actually applicable to what you have not disclosed? Did we follow our statutory requirements? Did we follow our office policy to the best of our ability? Did we provide the records in a reasonable amount of time? Did we help them revise? Did we provide the legal authority? You get what I'm talking about. So just when you look at the request and tailor your response and records to that request, view it the way a court would. If we are providing enough detail that a court would understand our position and agree, then you're doing it right. I also would encourage creating a well-oiled machine within your department for handling public records requests. Do the employees know where to send public records requests? Are they sending it to the right people? Do they have a contact list? Is there a policy? Is it understandable? Are the employees educated on it? Is very important. And is someone keeping up with the public records case law? Because it changes all the time. New cases come out several times a year, and it changes the way we have to work on requests. So is someone keeping up with that? All in all, communication is key, both with the requesters and between the employees within the office. My last portion is for the cases that have come out within the last year, since the last symposium, that have made some noteworthy changes to public records law. First up is Bott versus ODNR, and Bott was a 10th district case, and in that case, Bott made 3 requests for all responsive documents from a few years past to the present. ODNR, in good faith, attempted to recover all those documents and did send those out in a reasonable amount of time. The problem was, a year after the first request, Bott realized that some of those records were missing and made a complaint to ODNR. ODNR then gave them what amounted to over 7,000 pages of documents they had not received previously that they should have received. Bott then filed a mandamus action. The agency tried to argue a few things. One, that Bott did eventually receive all his responsive records, therefore the mandamus should be moot, and that the request was overly broad. The court held that an agency was required to promptly prepare in a reasonable amount of time all requested public records. A year later is not a reasonable time frame when those records should have been provided with the original request. Therefore, that was denied. Second, if an agency finds a request to be overly broad, like I've already stated, they have a duty to inform the requester that it is overly broad. A requester then has the duty to revise or narrow that request if they want those records, but that duty only arises after the agency has informed them that the request is overly broad. To cover all the bases in my office, we let the requester know that inasmuch as the request is overly broad, it is denied. This lets them know and makes it clear that they should not expect to be receiving all the records that they want. Finally, the Bott court held that an agency has a duty to retrieve all documents that were improperly deleted. So if an agency has gotten rid of emails before their retention schedule, they are still required to provide those improperly deleted emails, go into the archives to get them. For example, another way to look at it, if a requester makes a request today, the retention period ends tomorrow, you don't start working on it till next week, you can't use that retention schedule as an excuse. They were entitled to those records, even though the retention period has passed. So just be aware of that because that can cause problems. The next case is Carr. This was a 12th district case. 4 requests were made from a prisoner, and essentially the request was the same. They were seeking a single memo from the chaplain to the mailroom that listed religious ministries that regularly sent prisoners religious materials. The problem was Carr wasn't making the request very well. His first 3 requests were overly broad. His first request did not specifically or particularly describe the document, despite having a 2-month time frame, a sender recipient, and the format, which was a memo. But the court held that it was overly broad because he did not particularly describe the document. His next 2 requests became even broader, and he asked for all emails and interoffice memos sent from the chaplain to the mailroom for a 2-month time span. The court held that he was asking for a body of communication without offering any specific reference to a particular work activity, and therefore it was overly broad and a duplication of the record. His final request, which causes problems when we look at it in comparison to other overly broad cases, he asked for a copy of all memos and emails sent by the chaplain to the mailroom for March 5th, 2012. That date is what made the difference for this court. Even though he was requesting a body of communication, he had identified an exact date. He didn't identify the subject matter, but that date is what made the difference with this court. So comparing Carr to other public records, overly broad cases, some other cases have allowed for any and all records for a body of communication if they identify the subject matter. But in this case, he didn't identify the subject matter, but just a date. So the takeaway from this is There is no clear formula for overly broad, which isn't helpful. I know. So I would suggest going over your office policy and tinkering overly broad within your office so you have something to go off of, because the cases are district by district, and even within the district, they are not consistent. Miller versus Ohio State Highway Patrol. The requester wanted the video and audio from his traffic stop as well as the impaired driver report. The agency denied the release under the argument that they fell under the CLEARS public records exception. CLEARS is the confidential law enforcement investigatory records exception. Records relating to specific investigatory work product, which are exempt under disclosure from CLEARS, consist of any notes, working papers, memoranda, or similar materials prepared by attorneys or law enforcement officials in connection with an actual, pending, or highly probable criminal prosecution. A criminal proceeding is highly probable as long as it is clear that a crime has in fact been committed. Here, the court held that the video and audio, as well as the impaired driver report with the officer's own observations instead of a third-party recording, were in fact under the CLEARS exception and can be exempted from disclosure. The court also held that this does not include ongoing routine offense and incident reports because the incident reports initiate the investigation. They are not a part of the investigation. So just keep in mind that the audio and video, they're covered. We don't have to release them while that case is ongoing. The final one is Plunderbun versus Director of Public Safety. And in this case, the requester was seeking the disclosure of records documenting threats against the governor, specifically closed investigation reports setting forth the type of threat to the governor and whether it was credible or resulted in charges. The agency denied the request, arguing that they are security records, which are exempt from disclosure in their entirety. The requester tried to counter that they didn't want the information about actions taken in response to the threats, just the information on the threat itself, and that a public office, which is under the definition of security records, only refers to the physical building. However, the court held that a public office is broadly defined and includes not only the physical building, but the office holder and the employees as well. The court also held that not all records involving criminal activity in or near a public building or concerning a public office or official are automatically security records. But here, the records involve direct threats to the highest official of the executive branch of Ohio, and information in those records is used for protecting and maintaining security, and that's why they fell under the security records exemption. So just be mindful about what is and is not a security record, so we aren't delivering documents that could pose a possible threat. And that is all for me.
I promise you, I'm going to essentially do a wrap-up so we will still get done with this on time. Just want to talk about some practical applications and pitfalls. Some we've kind of touched on, but I feel that they warrant repeating. The biggest pitfall that our office and any office that I've worked with seems to deal with is the fact that we create and maintain records that we do not need. Technically and legally, a state public agency should only be creating those records that we need to perform our functions. So again, follow through, comply with your record retention schedules. That will alleviate a lot of public records request headaches. The other thing, as Jacqueline suggested, communicate, communicate, communicate. We are very fortunate that because even though we are a large agency, we do have a good solid group of people that respond to public records requests. So that's not just left up to the devices of anybody within our agency. And they receive training. We have a system that tracks all of that, so that makes our lives a little bit easier. If you can anyway automate that, that's a great thing to do. But if you can't, the key is to communicate with your staff so that they know that whether or not they are in fact authorized to respond to a public records request, If there's somebody else they should be going to, you need to make that clear because there will be lots of problems if we don't respond appropriately. Don't take requests personally. That can lead to a lot of stress. The thing that we have to remember is that under Ohio law, these are the citizens' records, so we have an obligation to provide those records when they're requested. And so if you think of it in that way, we're giving folks exactly what they're entitled to. Not more than they're entitled to, but those records that they're in fact entitled to. Requesters will get very, very frustrated because they don't understand the law and they may not understand your process. So again, whenever possible, take the opportunity to educate the requesters, communicate with them why it is that you're doing what you're doing. If you take it personally, again, it's going to cause a lot of headaches. Jacqueline is a perfect example. I want to say within, 2-3 weeks, maybe 4, of starting with our office, she was belittled and ridiculed by a requester during a conference call and personally named as a defendant in 2 lawsuits. So, yes. Had she taken that personally, she probably wouldn't be sitting here today. So keep that in mind. People that are making requests, they're reporters, they're citizens. They either want the information for their own personal purposes, and keep in mind they're entitled to that. They can have them for whatever reason they want. Or oftentimes just somebody else who's working for somebody and they're trying to do their job. So if you look at it that way, it's going to be less adversarial and be a better experience for everybody. Keep in mind you're not going to be able to please all of the people all of the time. So as Jacqueline said, you just want to make sure you do due diligence, that you follow the processes and you document that accordingly so if there are ever any issues. And lastly, this is my favorite saying, and if you've been here before when we've done these presentations, you'll know, when in doubt, check it out. It's often easy just to hand out things to people, and some people go, well, I'm not sure. And there are those that in fact will say, well, if you're in doubt, just go ahead and give it out. You don't want to do that because there are all sorts of ramifications. Again, we are very fortunate that we have a fairly well-oiled machine here at our department. Ask people if you're not sure. Ask your legal counsel. If you've got specific individuals within your agencies who are the ones that respond to public records requests, ask them. Take advantage of resources. The yellow book, the Sunshine Manual that the Attorney General's Office puts out is a wonderful, wonderful resource. It includes the public records law, but it also includes in plain English what it is that you should be doing and not doing, what our obligations are, both for requesters and for the public agencies. So oftentimes, savvy requesters will already have this book. And so some know it forwards and backwards. And so there are times when I say, you're not required to provide this information. However, they're like, oh yeah, I know I'm not required. You can't make me tell you this, 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 and this. So it's helpful to make yourself very familiar with these resources because these resources are public, and I can guarantee that public citizens are taking advantage of that. Take advantage of resources like interns if you have the opportunity to. Jacqueline stressed the importance of being up to date in terms of case law and other decisions that come out, especially in the different districts, because that's depending on where you're located, it's going to have a bigger impact. Jacqueline is a great resource for us. So you might have to think a little out of the box in terms of getting assistance. The other thing is take advantage of the people in this room, because oftentimes you are the ones that are responding to public records requests. Share that information. You may have similar experiences, similar resources that you can share amongst one another. And while we can't provide legal advice to you, feel free to call us. I will answer questions to the best of my ability. Again, you'll get that caveat. I can't provide you with legal advice, but we can certainly enlighten you in terms of how we deal with public records requests and provide you with any resources that we are able to. So with that, we are going to open that for questions. Yes. You have to have the question was with social media and Twitter accounts, and if somebody makes a request for something that you tweeted out last year and it's gone, what do? Well, first of all, it shouldn't be gone, because if you don't have a record retention schedule, you can't get rid of it. With Facebook, for example, you can take things off your Facebook page, but you have to retain them per your record retention schedule. It's not so much the other things that other people post, because it is interactive, but if you post press releases, for example, there's going to be a record retention schedule for that. When you take it down from your Facebook page, as long as you're retaining it pursuant to your already established retention schedule for press releases, you don't have to create a separate one. But, for example, somebody could come to you and say, I want a copy of what was posted on your Facebook page on January 13th, 2014. That is a valid public records request. The information that you put up there is your record, and you have to be able to provide that record. So it's important. A lot of times if you're reposting things, if it's not original content, you're already going to have an existing record retention schedule. But if you don't, and you don't have one that you can fit that record underneath, then you need to create one before you start getting rid of records. Any other questions? Yes? County and city agencies have the same requirements. You're a public agency. And in fact, hopefully county and city agencies take advantage of the training that the Attorney General's office puts on throughout the year to go over that. If you are a public agency, you're going to fall in some way, shape, or form under Ohio's public records law. So I would just say familiarize yourself with the requirements. The thing about public records and what makes it so interesting for me, probably not so much for the rest of you, is that we have within the law a list of specific exceptions: medical records, confidential law enforcement investigatory records. But then there's a catch-all exception. And that catch-all says any record the release of which is prohibited by state or federal statute. That's pretty much everything. So they're not going to be listed in there, but if you have a state statute, an ordinance, something that prohibits you from releasing those records, you need to make sure that you're aware of them. For example, the B&V is housed under our agency. There are specific requirements. There's what's called the Driver Privacy Protection Act. That's what prohibits us from releasing your name, your address when people call and they want information about your driving record. They get the record, so if you've had 5 DUIs, they're going to see that, but they're not going to have your name, your address, your social security, et cetera, because there's an exception for that. Again, it keeps it interesting because there's no way that one person can know every state law in Ohio and every federal exception, every federal law that says you can't release a record. So the thing is to familiarize yourself with those requirements that are most relevant for you. Nonprofits, if you are deemed a public agency, you still have to respond to public records requests. The other thing to keep in mind is that there have been court cases if you are an agency pretty much acting on behalf of a public agency, then more than likely in some instances your records are going to be public. So if we have private entities, private facilities that are standing in the stead, if you will, of a public agency, more than likely their records are going to be deemed to be public as well. Yes. You can do either. The more specific you can be, the better. The thing with emails, in case you ever come up with this too, is email is just a format. It's the correspondence. And so oftentimes the problem arises because agencies purge their emails. They start to fall off after 3 months or 6 months. that's not necessarily appropriate, and you may have to print those and save them. For example, general correspondence, the retention schedule is 6 months. If you have an email that is general correspondence, but your system deletes every 3 months, you still have an obligation to retain that email for another 3 months. And so the more specific you can be, the better. We have some people that know the system, particularly IT people. I want the emails, and they give a time frame. Saved, archived, deleted. They name everything that, so they cover it in its entirety. The more information you can provide, the clearer it's going to be, and the more likely that the agency is going to be able to respond to your request. In terms of your agency, I would just make sure that they understand that, emails may be deleting, but that doesn't relieve them of their obligation to retain those records per retention schedule. It's way in the back, sir. I think we have a duty, and there's not a lot of case law on that. We have a duty to retain anything that we post, certainly, and then anything that we may remove. For example, if we take something off because it's inappropriate, that's not necessarily that we're going to give it out, or we may give it out unredacted, but anything that we remove, we need to retain per a retention schedule because somebody could come back and ask for it. I think the court, as with everything else, is going to look at reasonable. As a threshold, is it reasonable to keep track of everything that everybody else may put up? The reality of it is if they post it, it's likely going to be there unless we take it down, and that's what we need to be responsible for. One more question, sir. So the question is, do we differentiate in terms of retention schedules with correspondence and emails? Typically, the retention schedule is for correspondence. Email is just a format. It's like a videotape. It's like any other format. You have to go with the content. So if the content is part of an investigation, then it might be, in our case, have to be retained 5 years because the investigation retention schedule is 5 years. The retention schedule typically will spell that out. So, for example, our retention schedule regarding public records request, the record series includes not only the request, but any correspondence we have with the requester and the responsive records that we provide to that requester. So all of those are considered part of the record request retention schedule. And I'm getting looks and people are walking towards me, so I'm guessing we're out of time.